This is part 7 of CrPC, chapter 17, the charge. We have already covered A form of charges from section 211 to section 217, and part B joinder of charges. We already covered section 18 in details, and now let's check section 219. The trick word to remember is 3YT, means 3 years time. It has two parts. Let's cover it in detail. Section 219. It says 3 offences of same kind within a year may be charged together. Now from the title of the section, it's clear. It says may be, so it's not mandatory. That makes things clear. Subsection 1 of section 219 says when a person is accused of more offences than one of the same kind. It further clarifies that if a person has committed more offence than one, should be of same kind. It should be kind of a similar. This makes a lot of difference when we prepare a charge. Further, it says committed within the space of 12 months from the first to the last of such offences. Now, a person who has committed more offences than one can be charged together, but they should be within the period of 12 months. And how we are going to calculate the 12 months? It should be calculated from the date of first offence to the date of the last offence committed by that person. The section further says whether in respect of the same person or not, which means it does not make any difference whether the person has committed an offence against one person or the offence he has committed is against 2 person or 3 person. The section further says he may be charged with and tried at one trial for any number of them not exceeding 3. Now, how many number of charges can be tried together? This is clarified in subsection 1, that he may be tried for not more than 3 offences. It can be for 1 offence, 2 offence, 3 offence, but not more than 3 offences. Now let's check what subsection 2 of section 219 informs us. Offences are of same kind when they are punishable with the same amount of punishment under the same section of the Indian Penal Code or any special law or local law. In simple words, if we ask what offences are called of same kind, well, the answer is when they are punishable with the same amount of punishment. And the next thing we understand is the same amount of punishment under the same section of the Indian Penal Code or any other special law or local law. So basically the same amount of punishment remains the same whether it is from IPC or any other law. Provided that, now there is a condition to it. For the purposes of this section means to charge 3 offences of same kind together which are committed within 1 year. And it further says an offence punishable under section 379 of Indian Penal Code shall be deemed to be an offence of the same kind as an offence punishable under section 380 of the said code, means IPC. And that an offence punishable under any section of the said code, again that is IPC, or of any special law or local law shall be deemed to be an offence of same kind as an attempt to commit such offence. When such an attempt is an offence, means when the offence is yet to be committed and when the offence is committed, shall be tried together. Now the punishment in both these situations is different. If you see section 379, the punishment is of 3 years, and if you see section 380, the punishment is of 7 years, but they will be tried together. This is what the condition is, which we should keep in mind while preparing the charge. Finally, we covered section 219, which has 2 parts. One part says if 3 offences are committed within 12 months must be tried together, and the second part says offences of same kind are those which are having same kind of punishments, which can be in any other law, not just IPC. Now let's cover section 220. It has got 5 parts. Let's check what they are. Section 220. Subsection 1 informs us if in one series of acts so connected together as to form the same transaction, more offences than one are committed by the same person, he may be charged with and tried at one trial for every such offense. I can make you understand by an example. A man commits a theft of a car. He injures the driver or the owner of the car. So an assault has been done. Later on, he sells the car to another person fraudulently, saying that this is his own car. He prepared forged papers of the car in his name as well to sell the car in his name to another person. Then he buys an illegal arm from that money. You can see there is a series of offense. An assault has been committed, a theft of the car has been done, a fraudulent sale has been committed, the money was taken fraudulently, and an illegal weapon has been bought by him from that money. So they may be more than 3 offenses, but they will be charged together. This is what subsection 1 of section 220 informs us. Now we come to subsection 2 of 220. It says when a person is charged with one or more offenses of criminal breach of trust, we call it CBT, or dishonest misappropriation of property, we call it DMP, just to remember it in a short form, as provided in subsection 2 of 212 or subsection 1 of 219, and the person is accused of committing for the purposes of facilitating or concealing the commission of that offense. Facilitating means to make something possible or easier, which means we are helping a partner in crime. Or concealing means to prevent something from being seen or known about, means the partner in crime is either facilitating, helping the person, or concealing is also helping a person by removing something as an evidence or hide something as a point of evidence. Further, it says, or those offenses, one or more offenses of falsification of accounts, he may be charged with and tried at one trial for every such offense. So there may be so many crimes like CBT, DMP, or even facilitating someone, or many kind of falsification of account, facilitating or concealing. There may be so many charges. All these charges will be tried together, and don't forget to read 212 and 219 for CBT and DMP. So subsection 2 of 220 says when a person is accused of one or more offenses of criminal breach of trust, means many criminal breach of trust he has done, or one or more offenses of DMP, dishonest misappropriation of property, or when a person has committed an crime of facilitating or concealing the commission of that offense, and when a person is accused of one or more offenses of falsification of accounts. So there are so many charges, but he will be tried together. This is what we understand from subsection 2 of section 220. Now let's cover subsection 3 of 220. It says if the acts alleged constitute an offense falling within 2 or more separate definitions of any law in force for the time being by which the offenses are defined or punished, the person accused of them may be charged with or tried at one trial for each of such offenses. It's very easy. Let me explain in this way. An offense which is falling within 2 or more separate definition of any law means maybe an offense stated in more than one law. It further explains that the offense may be either defined in that law or punished in that or the other law. You got my point? So such a person who is accused of them may be charged with and tried at one trial for each of such offenses, even if they are more than 3 offenses. Got it? Okay. Subsection 4. This is we need to understand. Subsection 4 of section 220. It says if several acts of which one or more than one would by itself or themselves constitute an offense. Try to understand this line. If several acts means there are many acts done by the person, of which one or more than one would by itself or themselves constitute an offense, means there are several acts of a person, and one of the act or more than one of the acts can be said to be a crime, an offense, or constitute when combined a different offense. So first part of subsection 4 informs us that when some of the acts of a person are itself a crime, but when we combine all those acts of the person, it's a crime of a different kind. Then the person who's accused of them may be charged with and trial at one trial for the offense constituted by such acts when combined, and for any offense constituted by any one or more of such acts, which is the first part of subsection 4. So in any of the two conditions, when charged, it will be tried together. Now the last one, subsection 5, it says nothing contained in this section shall affect section 71 of Indian Penal Code. Now what 71 is? The section 71 of IPC says limit of punishment of offences made above several offences. Now we come to illustration part. This is important only from judicial examination point of view, IS examination point of view, not from LL.B or LL.M degree point of view. Anyway, let's cover it. A rescues B, a person in lawful custody, and in doing so causes grievous hurt to C, a constable in whose custody B was. A may be charged with and convicted of offences under section 225, 333 of Indian Penal Code. Let me explain. A rescues B. Who is B? A person who is in lawful custody. Lawful custody means in a jail. In such rescue act, A causes grievous hurt to C. Now who is C? A constable in whose custody B was. So series of crime has been committed by A. That's why it says A may be charged with and convicted of offences under section 225 and 333 of Indian Penal Code. Now be a good student. Write down in comments what are section 225 and 333 of Indian Penal Code. Second illustration, B. A commits housebreaking by day with intent to commit adultery and commits in the house so entered adultery with B's wife. So I hope you understand. A has entered somebody's house by breaking the house. His intention is to commit adultery and he commits adultery. So what he will be charged with? A may be separately charged with and convicted of offences under section 454 and 497 of Indian Penal Code. Let me tell you, adultery section 497 was a crime at that time. But remember, this illustration says he may be charged separately, not together, because breaking a house by day is another sort of a crime. Adultery is another factor. Another one, it says A entices B. Entices means to attract, to elicit, or to tempt someone. Now what he is doing, he is trying to attract C's wife B away from C. And what is his intention? His intention is to commit adultery with B and then commits adultery with her. Now A may be separately charged with and convicted of offences under section 498 and 497 of Indian Penal Code. Let me remind you again, adultery was a crime at that time. It's not a crime right now. But if the law changes, I will give that in description below. Another one. A has in his possession several seals. Keeping a seal is a crime. Many people doesn't know that they should be having an authorized letter even if they carry in a legal manner. Anyway, in this example illustration, we see that knowing them to be counterfeit means he knows that they are fake as well. And what is his intention? Intending to use them for the purpose of committing several forgeries. Obviously, that's why he was keeping fake counterfeit seals with him. Anyway, these offences are punishable under section 466 of Indian Penal Code. Now A may be separately charged with and convicted of the possession of each seal under section 473 of Indian Penal Code. So you understand, every seal has a state of crime distinctly. That's why for every and each seal, he may be tried separately. Next illustration. With intent to cause injury to B, A institutes a criminal proceedings against him. Now this is a common factor these days, whenever you want to hurt someone, whenever you want to take some kind of a revenge, a false case is filed against another person. So this is what in this illustration is given. With an intent to cause injury to B, A institutes a criminal proceeding against him. Now this is a common factor these days, whenever you want to hurt someone, whenever you want to take some kind of a revenge, a false case is filed against another person. So this is what in this illustration is given. With an intent to cause injury to B, A institutes a criminal proceeding against him. knowing that there is no just or lawful ground for such proceedings, and also falsely accuses B of having committed an offence, knowing that there is no just lawful ground for such charge. If such thing happens, a counter case can be filed. This is what the illustration says. Now, A may be separately charged with and convicted of two offences under Section 211 of Indian Penal Code. I hope that clarifies things. Now, Section 211 of IPC is given in Chapter 11. Write down in comment what is Section 211 of IPC. I'm asking you to do these things because you will remember this in examination as well. Now check this illustration. A, with the intent to cause injury to B, falsely accuses him of having committed an offence, knowing that there is no just or lawful ground for such charge. We already covered such illustration, but there is a difference in this one. It says, on the trial, A gives false evidence against B, intending thereby to cause B to be convicted of a capital offence. This is serious. This is serious matter now. He gave false evidence so that B can be convicted of a capital offence. I don't think anyone can forgive that. Anyway, illustration says A may be separately charged with and convicted of offences under Section 211 and 194 of the Indian Penal Code. If you have found Section 211, I'll help you explain Section 194 of IPC. It says giving or fabricating false evidence with intent to procure conviction of capital offence, if innocent person be thereby convicted and executed. Check this in detail in Chapter 11 of IPC. Let's check another illustration. A with 6 others. This means a person A is with 6 other persons, commits the offence of rioting, grievous hurt, and assaulting a public servant enduring in the discharge of his duty as such to suppress the riot. Now, whenever you see a news on riot, an law student advocate must remember these sections. Which sections? Let's check that. A may be separately charged with and convicted of offences under Section 147, 325 and 152 of Indian Penal Code. Now, Chapter 8 of IPC is on public tranquility. You can find Section 147 over there, that is punishment for rioting. And Chapter 16 is on offences affecting human body. See, we will cover IPC and so that you can recall all such things quickly. Section 325 is regarding punishment for voluntary causing grievous hurt. If you see the illustration, we saw that A and 6 others commit the offence of rioting and grievous hurt and assaulting a public servant. Now the third thing is assaulting a public servant, which is given under Section 152 of IPC. And Section 152 of IPC says assaulting or obstructing public servant when suppressing riot, etc. Don't get bored. Reconnect all such things so that whenever such a question comes in competition, you must be capable to answer that quickly. Illustration H. A threatens B, C and D, 3 persons at the same time, with injury to their persons and with intent to cause alarm to them. Now this seems to be a real gunda. The illustration further says A may be separately charged with and convicted of each of 3 offences under Section 506 of the Indian Penal Code. You got the point? There are 3 different things. A has threatened B, A has threatened C, A has threatened D as well. But he may be charged for all these threats given to any of such persons together. Now these illustrations were of subsection 1 of Section 220. The separate charge referred to illustration A to H respectively may be tried at the same time. This is what the Bail Act says and you must remember as well. Now let's cover illustration to subsection 3 of Section 220. Illustration I. A wrongfully strikes B with a cane. Whenever you read something like this, it must instantly come to your mind that this is an assault. The illustration further says A may be separately charged with and convicted of offences under Section 352 and 323 of Indian Penal Code. 352 is punishment for assault and 323 is punishment for voluntary causing hurt. Next illustration is J. Several stolen stacks of corn are made over to A and B, who knew they are stolen property for the purpose of concealing them. A and B thereupon voluntarily assist each other to conceal the stacks at the bottom of the grain pit. A and B may be separately charged with and convicted of offences under section 411 and 414 of Indian Penal Code. Now, in this illustration, they had taken stolen stacks of corn and even helped each other in hiring it. Obviously, this is a crime. And what type of crime? That's given under section 411, which is dishonestly receiving stolen property, and section 414, assisting in concealment of stolen property. I hope you understand this illustration. Illustration K. A exposes her child with knowledge that she is thereby likely to cause its death. Exposes the child means neglectfully keeping the child in sun or in some danger places, or leaving the child unattended some outside area. Well, due to the act, the child dies in consequence of such exposure. A may be separately charged with and convicted of offences under section 317 and 304 of Indian Penal Code. Section 317 says exposure and abandonment of child under 12 years of age by parent or a person having care of it. And 304, everybody knows it, punishment for culpable homicide not amounting to murder. Next, illustration L. A dishonestly uses a forged document as genuine evidence in order to convict B, a public servant, of offence under section 167 of Indian Penal Code. A may be separately charged with and convicted of offences under section 471, read with 466 and 196 of that code. See, these illustrations, like A dishonestly uses a forged document as a genuine in order to convict B, a public servant. This should be connected with section 167, 471, 466, 196 of the IPC. Immediately these sections should come to your mind. If in an examination illustration is given, they may ask under what section of IPC you will convict such person. So covering these illustrations are very important. Now we come to illustration M. This is illustration 2, subsection 4 of section 220. It says A commits robbery on B, and in doing so voluntarily causes hurt to him. A may be separately charged with and convicted of offences under section 323, 392 and 394 of Indian Penal Code. See, learning IPC may not be very easy, but if we remember all such illustrations, at least we will learn some of the sections of IPC. So you must watch this lecture again and again, and automatically you will learn at least some section of IPC. Section 323 is punishment for voluntarily causing hurt. Section 392 is punishment for robbery. Section 394 is voluntarily causing hurt in committing robbery. So IPC 1860 also covered in indirect manner. Let's take a break. Before we come back again, a little request. Respect elders and love kids. The world will become a better place to live.